Professor Jerome A. Barron is a magna cum laude graduate of Tufts College in Medford, Massachusetts. He holds the LLB degree from Yale and the LLM from George Washington University. He has taught law at the University of North Dakota, the University of New Mexico, and the National Law Center of George Washington University. He was Dean of the College of Law of the University of Syracuse during the 1972-73 academic year, but he resigned that position to return to the National Law Center this fall. Professor Barron is a member of the Massachusetts and District of Columbia Bars, of the American Bar Association's Committee on Free Press and Fair Trial. He was a law clerk for the Chief Judge of the United States Court of Claims and was involved in private law practice with a Washington, D.C. firm. Professor Barron is co-author with Donald M. Gilmore of one of the two major textbooks in the field of mass communications law. A new edition of this work will be published next fall. Tonight's lecture will deal with the subject of required access to the print media. Professor Barron's suggestions on the subject first sparked controversy in 1967 when his article, Access to the Press, a New First Amendment Right, was published in the Harvard Law Review. His subsequent articles on access in the George Washington Law Review and the Texas Law Review continued to pull the interest of professionals in law and in journalism. Then this spring, his intensive and extensive research on the subject was published in book form. The book is entitled Freedom of the Press for Whom? The Right of Access to the Mass Media. The debate concerning required access is apt to continue for some time, for a basic constitutional question is involved. A recent Florida Supreme Court opinion has upheld Professor Barron's basic thesis, but Bill Monroe of the National Broadcasting Company only this week took occasion to express his disagreement with that opinion in this building. I suspect that the controversy will become more heated in the months and perhaps the years ahead. Jerry Barron is here tonight, most specifically, to offer his ideas concerning the meaning of the First Amendment in contemporary society. His topic is contemporary developments in the movement for access to the media. Jerry?
Well, thank you very much for inviting me here to speak to you here at Iowa State. I think what I'll do is make some general remarks on the new developments in the field of access to the media, and then I'll open the floor to hostile questions, or just questions. Usually, my experience has been that I think so thorough is the so thorough has the communications industry been in its saturation of the public with a view of the First Amendment as exclusively protecting the industry and no one else, that I think when we talk about access rights, we think of it too often just in Orwellian terms, as if government is, if what's being advocated is that government somehow direct the hand of the editor. And I hope that as you listen to me tonight, whether you agree with me or not, you'll see that really that isn't what I'm talking about at all. There have been two major developments in the field of access to the media, which I would like to talk to you about. One of them involves a considerable defeat for access to television, and the other one involves a considerable victory for access to the press. In May 1973, this year, the Supreme Court, in a case called CBS against Democratic National Committee, dealt a blow to the view that the force of the First Amendment in itself was sufficient to require the broadcast networks to abandon their policy of refusing to sell time to political groups and parties for the dissemination of views about ideas. The Supreme Court took the position that so long as the FCC, the Federal Communications Commission, neither forbade nor required the networks to take any particular position with regard to the sale of political time, what the networks did was private action and therefore removed from any kind of constitutional obligation. Although the CBS case squarely endorsed the fairness doctrine, the opinion was a defeat for the view that the First Amendment supports an access-oriented interpretation, which gives a right of entry, at least as a general proposition, to political and social ideas and over and against commercial ones. Counterpoised against the defeat for access reflected by the Supreme Court's decision in the CBS case was the remarkable victory for the establishment of a First Amendment right of access to the newspaper press, which was reflected in the now celebrated decision of the Supreme Court of Florida in the Tornillo case, a case which I understand Bill Monroe condemned here recently. And I think it's appropriate that I should talk to you about it since I argued the Tornillo case in the Supreme Court of Florida. And I was very happy that we won, although I must say I was a little surprised at the magnitude of our victory, since out of 7 judges, we got 6 out of the 7. And I welcome, since you've already heard about the Tornillo case, the Florida case, an opportunity to talk to you about it and see why I think it is a case which whom everyone who believes in freedom of the press should really rejoice in rather than grieve about. So I've talked to you really about 2 situations, the CBS case and this case in Florida, named after the man who brought it, Pat Tornillo. And since it's pleasanter to speak of victories and defeats, I'll start with the Florida right of reply case with you. It's an interesting case, really. A provision of Florida law enacted way back in 1913 provides that when the publisher of a newspaper assails the personal character of any political candidate or charges him with malfeasance or misfeasance, the newspaper, upon request of the candidate, has to publish free of cost any reply the candidate may make thereto in as conspicuous a place and in the same kind of type as the matter that calls for the reply, which is lawyers' English for saying that you got to give them as much space to reply as you took to attack them, and you have to give it free. Now, this statute had been slumbering down in Florida for more than half a century. The new interest in the First Amendment right of access sort of revived it. And it was revived in this way. A man named Pat Tornillo ran as the Democratic candidate for the Florida nomination of the Democratic Party, for the Dade County nomination, rather, which is Miami, a nomination of the Democratic Party in the House of Representatives in the state of Florida. And Tornillo ran there in '72. Now, in 1968, the Dade County classroom teachers had gone on strike. You may remember that strike, which Governor Kirk, I guess as he then was very upset about, said it was illegal and so on. And Tornillo had led this strike in Miami. He was a leader of a teachers' union. The Miami Herald on September 20th, 1972, published an editorial and said that Tornillo was a czar and a lawbreaker. And then they said in the editorial, quote, "It would be inexcusable if the voters sent Tornillo to the legislature." Tornillo sought to reply to these editorials under this Florida law I told you about. The Herald, and he asked the Miami Herald to print his replies under the law. And Tornillo, of course, they refused. I was amused at that because their complaint about him was that he was a lawbreaker. It's against Florida law to go out for teachers to strike. So then he asked for a right of reply, and they said, well, they weren't going to give it to him. And he said, well, that's the law that I have it. And they said, well, they weren't going to follow the law. Anyway, they went to court about it, and the lower court said the statute was unconstitutional. And the Attorney General of the state, and just it's a matter of general information, it is when a state statute is declared unconstitutional, almost always the Attorney General of that state will defend the statute in the Supreme Court of the state or in the trial court, wherever it's attacked. But the Attorney General of Florida said this particular statute is so unconstitutional that he couldn't defend it. Tornillo appealed to the Supreme Court of Florida, where his counsel met an odd pair of allies lined up as amicus curiae, or friends of the court, with the counsel for the newspaper, the Miami Herald, the American Civil Liberties Union, and the Office of the Attorney General of the state of Florida. I would wager that is the first time that the judges on the Supreme Court of Florida had seen the ACLU and the state of Florida on the same side in a long time. I don't want to suggest to you the ACLU is against access in every state, or every local is against access. It has been an issue of great conflict in the American Civil Liberties Union. For the same reason, it is a controversial issue generally, because it depends on how you look at the First Amendment. And I think that it reflects the cross-currents in First Amendment litigation today. For example, in 1968, the National Biennial Convention of the ACLU went on record for a right of access, but the National Board set the action aside. Ever since, various ACLU chapters have disagreed on whether a right of access to the press, of which the right of reply is one illustration, is or is not consistent with the First Amendment. Now, the Supreme Court of Florida, as I said, held that the statute, the right of reply law I told you about, was constitutional. Why? Why did they hold that? Well, I think I'd like to share with you some of their few remarks from the case, because it might give you an idea of the view of the First Amendment that I take. As I say, I argued this case. They say, what some segments of the press seem to lose sight of is that the First Amendment guarantee is not for the benefit of the press so much as it is for the benefit of us all. The Supreme Court of Florida recognized what I believe to be a crucial distinction between right of reply legislation and direct restraints on content, which the First Amendment classically guards against and should guard against. The court explained this difference as follows. They said a right of reply law isn't designed to hinder the flow of information, since, in fact, it's to encourage it. No specified newspaper content is excluded by a right of reply law. In other words, there is nothing prohibited, but rather it requires additional information. Some believe that the exclusive addressee of First Amendment is the press. Others believe that the First Amendment is designed to provide all members of the public with the necessary information to make the informed judgments which a democratic society presupposes by way of obligation from its members. The court said in the Tornillo case, freedom of expression was retained by the people through the First Amendment for all the people and not merely for a select few. The First Amendment did not create a privileged class which, through a monopoly of instruments of the newspaper industry, would be able to deny to the people the freedom of expression which the First Amendment guarantees. And I think the decision reflects the ferment about First Amendment theory which we've had now in law and journalism circles for nearly a decade. I think it's very important that we've gotten this result. The Miami Herald has pledged to appeal the case to the Supreme Court of the United States. And newspapers, I can tell you, lawyers for newspapers are stepping on each other with anxiety and eagerness to file briefs amicus curiae in the Supreme Court against the Supreme Court of Florida's decision. So there has been a great deal of newspaper interest in this case. The movement for a First Amendment-based right of access to the press has been sparked, I think, probably by the increasingly non-competitive and chain-dominated character of the American press. Another powerful stimulus was the Supreme Court's groundbreaking decision in New York Times against Sullivan, which those of you who have studied journalism law I'm sure know about. And this 1964 Supreme Court case very radically revised the American law of libel and provided a measure of relief from libel judgments hitherto unknown in American law. These developments took an even greater impetus in a recent case in 1971 when the Supreme Court in a libel case, the Rosenblum against Metro Media, said, well, maybe the answer, now that we no longer have damages so readily available in libel suits, is to have right of reply legislation. That argument was very strongly relied on before the Florida court, that a section of the Supreme Court had said that right of reply legislation might be the necessary recompense to sort of redress the new advantage that the press had won in the relative immunity from libel that it now enjoys. The idea expressed, maybe I can express it this way, would be this, that if damages are not to be a remedy for libel, perhaps a right of reply can perform that task. Damages won in a libel action are perhaps a burden on the information process, but a right of reply statute aids the information process in the sense that it provides for access for the person attacked. And that theory is, I think, very definitely one of the principal ideas of the access concept. That is the idea that if newspapers are going to now enjoy a new privilege, as they do since 1964, and freedom from libel, it may impose some new responsibility, which is, since the theory of making immunity for libel, since that theory is to encourage vigorous debate, then the idea of right of reply legislation is to actually see to it that we really have such debate. Now, the free space requirement was attacked in the Florida case by the Miami Herald, by their lawyers, because they said that it was a burden and it was a taking of their property. But, you know, we have free time in broadcasting, and that has been sustained. And broadcasting time, unlike newspaper space, is finite. A newspaper is, of course, a much more expandable commodity than the broadcast day. If advertising business is up, the paper can put out a larger edition. This is not the situation in broadcasting, where the broadcast day, and particularly the prime time day, is necessarily limited. And a grant of free time is a much more costly matter to the station manager in broadcasting than is a grant of free space to the newspaper publisher. But the basic factor, I think, in evaluating the free space provision of a right of reply law is that the notion of property as a barrier to free expression is completely foreign to whole other areas of our modern First Amendment law. For example, we have had Supreme Court cases saying that picketers have a First Amendment right to enter a privately owned shopping center. Mr. Justice Marshall said on that subject, I summed it up this way in my new book, Freedom of the Press for Whom. Access to property for purposes of communication is not dependent on whether property is ordinarily open to the public. This is how I explain it anyway. The underlying concept seems to be that when property is open to the public for every purpose except the presentation of views unwelcome to the owners, it should be open to the public for that purpose too. This dedication to public use theory has been applied to public property. The remarkable and pioneering feature of these cases is that the Supreme Court has applied a right for ideas even to private property. Now, it is no more unconstitutional for plaintiff to give free space to implement First Amendment objectives of debate than it was deemed unconstitutional to rule that privately owned shopping centers, for example, may be used for the exercise of First Amendment rights. It's never been suggested in the shopping center cases that payment had to be made, and I think the suggestion is particularly frivolous with regard to a statutorily recognized right of reply. If there are only one or two daily newspapers in a community, I don't think that ownership of them by a publisher must mean, in fact, I don't think it does mean, that the publisher has absolute dominion over every inch of space within them. If the publisher opens up his pages to abuse a political candidate, surely it is a strange conception of debate or of free expression which would hold that the legislature is powerless to prevent such a publisher from keeping the political opposition in his community forever mute. Right of reply laws don't deprive the newspaper of property without due process. Instead, they provide a deeply felt need of political candidates for fair debate and reply. Now, I promised you that I would talk about defeats as well as victories, and the big defeat, I think, to Access came, as I said, in the CBS case that was decided this year by the Berger Court. Way back in May of 1970, the Democratic National Committee had asked the Federal Communications Commission to order the networks to recognize the general right of access to purchase television time to present commentary and discussion on current and controversial political and social ideas. And it may interest you to know that that buying time, a half-hour block of time to buy some time to discuss an idea, was not then and is not now an easy thing to do. The networks took this position. They said that they didn't sell time to groups for unedited use, that if they wanted to put on a public affairs programming, they put on their own. That was CBS's position, as well as that of ABC. NBC said it might sell some time, but it wasn't very clear. ABC and CBS refused to recognize any right or obligation on their part to sell time to the Democratic National Committee or any party or any group at all. The Democratic National Committee, this was during Cambodia, the invasion of Cambodia, and they wanted very much to get their view across about Cambodia, and they asked the FCC to issue a declaratory ruling. This is what they wanted the Commission to say. A broadcaster may not, as a general policy, refuse to sell time to responsible groups such as the Democratic National Committee for solicitation of funds and for comment on public issues. The FCC refused to issue any such ruling and stated that broadcasters weren't required to sell anyone blocks of time for political and social commentary. And Commissioner Johnson, the dissenting commissioner on the, Commissioner Nicholas Johnson, said at the time in dissent, he said, you can buy unlimited time for soap and deodorants to sell them, but no time for ideas. And that really was the case. That's why they sought this ruling from the Commission. But the FCC agreed with the networks rather than with the Democrats, and another group joined the Democrats. The Business Executives Move for Vietnam Peace joined with the Democrats to appeal the FCC's refusal to prohibit broadcast licensees from enforcing a blanket policy against the sale of time for the dissemination of and discussion of political ideas. I have a very hard time, even if I give you these facts, to think that the people who did this say they're for freedom of the press, but that is what they say. They say that that their freedom of the press is manifest when they refuse to let anybody in the country but themselves decide who shall have access to television. But that is their position. And what happened was the Democrats and the business executives for Vietnam Peace were lost in the agency, lost before the Federal Communications Commission. But they won in the United States Court of Appeals for the District of Columbia. The Federal Court of Appeals reversed the FCC and granted the existence of a limited right of access to radio and television for paid public issue announcements. And Judge Skelly Wright wrote a long and thoughtful and scholarly opinion. It can be described best as making a fundamental statement that ideas cannot be discriminated against on broadcasting, because Wright took this position. If the First Amendment protects anything, it gives a preference to political discussion, to public discussion. And yet you have just the opposite in the networks. Unlimited time to sell commercials, but opportunity only at the grace of the networks for time for ideas presented by groups other than themselves. So what Wright made a few fundamental points. in his Court of Appeals decision that commercialism as a policy was not to be preferred over ideas, because he said to rule otherwise was to invert all traditional conceptions of First Amendment protection and to exalt commercial advertising over the discussion and the dissemination of social and political ideas. According to the Federal Court of Appeals, broadcasters were not going to be permitted, as they wished, to reserve all their advertising time for the sale of commercial products such as gasoline and candy bars and soap and deodorants, important as those things are, and none for ideas. Now, the victory for access to television won in the Federal Court of Appeals in 1971 was lost when that decision was in turn appealed to the Supreme Court of the United States in the decision that I told you about that was announced this summer. That decision was greeted with great disappointment by broadcast citizen groups throughout the country and with great joy by the broadcast industry. Broadcasting Magazine, I don't know how many of you see Broadcasting Magazine. Do you see that? You know Broadcasting Magazine? I always think of Broadcasting Magazine as sort of the brontosaurus of broadcast industry opinion. And they didn't let me down. They reported the case under the following caption. That was on their cover the week the CBS case was announced by the Supreme Court. They say, broadcasters get their First Amendment back. Now, to me, if you suggest that the broadcast industry has its First Amendment back, maybe you're suggesting also that it's been taken away from somebody. But I will leave the implications of all this rejoicing and grief and so on aside for the moment and to tell you a little bit about the case. Chief Justice Burger delivered the opinion of the court, if it may be called that, in view of the fact that only one part of his four-part opinion was joined in by other justices, and then only two joined, Justices Stewart and Rehnquist. What was really attempted in the CBS case, and that's why it's important, was to launch a constitutional attack on private censorship. When we were always used to thinking of public censorship. And the attempt of the networks to reserve the right to exclude the sale of time for the dissemination of views about politics and ideas was resisted on the ground that such exclusion violated the First Amendment. A factor which apparently weighed very heavily with the court was the fairness doctrine. Now, a lot of you will be familiar with the fairness doctrine. This is the rule which we have codified in Section 315 of the Communications Act, that every broadcast licensee is obligated to make a balanced presentation of controversial issues of public importance. And so the way Burger reasoned for the court was this: we have fairness, therefore we don't need access. Well, you may say to yourself, what's the difference? Well, there is a big difference, because under the fairness doctrine, it's the licensee, the station owner, who chooses who's going to go on. In other words, if I put on a program saying that fluoridation of the water is good, and then there are groups in the community who think fluoridation of the water is bad, if I decide that that is an issue that should be well ventilated, it is up to me to pick the group that will reply, up to me, the broadcaster. You see, in other words, there are no specific rights of entry to any particular individual or group under the fairness doctrine. Access is a different thing. What you're saying is one that you have some specific rights of entry anyway, and for another thing, it doesn't really depend on whether the broadcaster has first decided that an issue is important enough to be covered. You see what I mean? In other words, fairness, the broadcaster first decides something should be covered. And then you get into the question of whether another aspect of it should be covered. And if you decide, yes, it should be covered, then it's up to the broadcaster to decide who will be the debater. In other words, in the fairness doctrine, the broadcaster chooses both debaters. And on access principle, the broadcaster neither chooses the issue nor does he choose the debaters. So it's a quite different concept.
Now, as I said, and I think this can't be emphasized enough, that in the fairness doctrine, admission to the airwaves is the broadcaster's choice.
Now, a major portion of the Berger opinion is devoted to the issue of whether the public themselves have any rights in television or radio time. And Berger really took the position he didn't have to get into that because he said the networks are really private persons. And a major part of his opinion is devoted to the issue of whether private censorship is subject to First Amendment obligation. And he said, well, it isn't, because there's no state action. Well, when constitutional lawyers speak of state action, what they mean is that constitutional duties don't arise unless government has restrained freedom. Since the First Amendment speaks to Congress, and the First Amendment speaks to, and the 14th Amendment speaks to the states, the argument is that if a non-governmental source infringes freedom of expression, such an infringement does not rise to the dignity of a constitutional violation. In this connection, the court said that private power aggregates, such as the broadcast media, shouldn't be viewed as quasi-public in order to satisfy the state action requirement. The court said that as private parties, the broadcast media owe no First Amendment duties, that if the state action problem could be sufficiently bridged for the broadcast media, it could be broadened for the print media as well, and this would be unthinkable. Now, a number of state action theories were advanced and rejected in the CBS case. One was the idea that licensees of the public frequencies are governmental actors, in this sense, that the only reason you're a broadcaster is because government has given you a license, so there's an interdependence there between government and the broadcaster. Berger insisted that the failure of the FCC to take a position on the question of access for the purchase of editorial advertisements made it clear that there isn't any state action evident on the facts of the case. Suppose the FCC had endorsed the position of the Democrats and the anti-war group there. Well, apparently it would have been an entirely different case. What he's saying is that if the FCC had a limited access rule, if the FCC itself said that networks have to sell 5% of their time within on a monthly basis for editorial advertising, that would have been an entirely different matter, because then that would be part of the FCC's authority under its public interest, under its power to define the public interest under the Communications Act. And he suggests that might have been constitutional. What he is saying is, and what the court said in CBS, is that the First Amendment, they're not going to interpret the First Amendment itself to require a right of access. Congress or the Commission is going to have to put it either in a regulation or a law first. So in that sense, there is still hope if you're interested in access to the media. There is still hope left by the Chief Justice's opinion for a right of access to the electronic media. Certainly, the Chief Justice is assuming that acquiescence in the Democrats' view would mean unlimited time for purchase for editorial advertising. I don't think that's what they were asking for at all. What they were saying was not that anybody had an absolute right to buy time. They were saying something different. They were saying that the networks cannot have a position that they will never sell time for ideas to anybody else. That policy, that blanket rule, it was the argument of the groups taking this case to the Supreme Court, was contrary to the First Amendment, you see. In other words, if you're going to have advertising time for everything on the sun, under the sun except ideas, that seems to be an offense to the First Amendment. And the Chief Justice really didn't meet that argument completely. What he says is, well, the networks are private persons. A private person doesn't have to afford free speech, and that is true. I mean, you don't have to open up your living room to all ideas under the sun because you're a private person. If the state of Iowa runs a paper, in fact, we have now a lot of state university newspaper cases. Those of you who are in journalism law, I'm sure know. And in those cases where you have a state university newspaper and they sell ads to some groups and not others, the courts have said, well, you can't have a policy of choosing some because you like their ideas and not others. Why? Because that's state action, you see. You've got the state involved. My own position is that when you have people who are really operating on governmental franchises, and when the marketplace of opinion in which they are operating is entirely governmentally created, that really what you've got is a delegation of censorship from the public to the private, but with the same consequence as any censorship. Well, has the whole movement for a constitutional right of access to the broadcast media been fatally wounded by the CBS case? Is the court's decision a major setback for a right of access to television? Well, it's difficult to say. On the credit side is the fact that the court's restatement of the fairness doctrine is very similar to the language of the access concept. The message that the Supreme Court of the United States is trying to get across in the opinion for the court, and they were all different opinions in the case, is this, that access isn't necessary because the fairness doctrine is an adequate vehicle to require affirmative efforts on the part of broadcasters to ferret out controversial issues of public importance. Now, the fairness doctrine is described as requiring an affirmative effort to seek out and present the whole spectrum of controversial issues of public importance. But this statement of the fairness doctrine, in my opinion, has an access component. The broadcaster must go and actively participate in the process of securing access for ideas. It may interest you to know that the harshest opponent of any affirmative view of the First Amendment turns out to be Mr. Justice Douglas, who wrote a separate concurrence in the CBS case. He agreed with Justice Berger, and he took a rather surprisingly fundamentalist First Amendment view. He says the constitutional structure as it bears on the press may be largely aligned on the side of the status quo. He said that may be true. But his answer is that we may need a new First Amendment. I don't agree with that, but that's what he says. He says unless such a rewriting occurs, he isn't going to hold any structure for debate that is governmentally imposed to be constitutional. In other words, he announces his intention to stick really to that old-time First Amendment religion and maintain the private-public action dichotomy. And in his opinion, he struck out at all the phantom demons which allegedly afflict the private-owned media. He said that he's against public broadcasting, the fairness doctrine, and a right of reply to the print media. All were scored as violating the First Amendment. And I was very disappointed in his opinion, needless to say. And I was surprised a little bit. As I mentioned earlier, in the Red Lion case in 1969, the Supreme Court said that the fairness doctrine in broadcasting was constitutional, and that was a unanimous decision. All seven of the justices who participated in the case reached that conclusion. And I remember that our textbook on mass communication law, I wrote the broadcasting chapter in it, and it was decided just as we were getting the proof in. And I heard on the radio they decided the Red Lion case, and I had the Court of Appeals case in the book. So I raced down to the Supreme Court. My wife wasn't home, so I remember taking the baby to the Supreme Court to get the opinion to see what the Supreme Court had held, hoping that they hadn't said the fairness doctrine was unconstitutional, because I wouldn't have liked that. But they said it was constitutional. They said it unanimously, and I was very eager to see what Mr. Justice Black had said, because as we all know, it is impossible to overestimate the contribution of Mr. Justice Black and the influence he has had on modern First Amendment theory. And I was delighted to see that he joined the court's opinion. He was part of the unanimous court. And since Justice Douglas, as so many of you know, I'm sure, so often voted with Justice Black in the court, I was very disappointed that he felt compelled to reach the conclusion he did here. Justice Brennan wrote a dissent, and before I close and open this up to questions, I want to make a few remarks about that. He wrote a dissent joined by Mr. Justice Marshall, and he said that network policy in this regard really amounted to governmental action. And he gave a number of reasons, and I'd like to share those with you. He said he relied on the fact that of the public ownership of the airwaves, that the people own the broadcast frequencies, and they are merely franchised on a 3-year basis. And he also cited the extensive governmental control over the broadcast industry. And he also pointed to the specific governmental involvement in broadcaster policy. And I thought he had a very good argument in this respect. He said the broadcasters were saying, well, they got the fairness doctrine, so that means that they don't need access. He said, well, why do they have the fairness doctrine? Because the government requires it. If the government requires it, then they are interdependent with government, and therefore there is state action. In other words, they can't have it both ways. I thought that was a good point, but I guess it wasn't good enough because it didn't get a majority. But anyway, it's a point that I think bears some thinking about. Also, Mr. Justice Brennan quite properly said, in my opinion, that the court seriously overestimated the usefulness of relying on the fairness doctrine as an adequate alternative to editorial advertising. He doubted the ability or willingness of broadcasters, and I'm quoting now from Mr. Justice Brennan, to, quote, expose the public to the widest possible dissemination of information from diverse and antagonistic sources. Access to the broadcast media was stimulated in the first place by the inadequacies of the fairness doctrine. Now the fairness doctrine is being invoked to strangle the access concept. But the result, if you want to look at things optimistically, and as you go through life, I suppose that's the only way to look at them, it is possible that this statement of the fairness doctrine by Chief Justice Burger will lead to a much more vigorous fairness doctrine than we've had in the past, if the court's serious about what it is saying. Now, let me make another observation to you. Divergent in conclusion as they are, the high impact estimate of television is, in my mind, the root of both Chief Justice Burger's opinion for the court and Mr. Justice Brennan's dissent. In other words, they are both writing their opinions because they both share a view of the enormous impact of television on our society. But that impact leads them to different conclusions. Chief Justice Burger says, well, if we allow people to buy time for television, for ideas, that will mean that just the richest people will be able to buy up the most time for their ideas. Commissioner Nicholas Johnson, in dissent, by the way, in the FCC, when that argument was made, said, well, that's who sets the agenda now anyway, and what difference does it make? And that's not and the fact that some of us are wealthier than others is not an argument against the fact that some of us are equipped to buy newspapers and broadcast stations and others are not, which I think is a good point. And also, Commissioner Johnson made the point that we cannot help but have different ideas, being exposed to different ideas, even taking into account the Chief Justice's observation. Now, Brennan takes a different estimate of the high impact of television. And he sees what I have long contended, which is that we really have a delegation of censorship. We don't have freedom of the press by what's going on now. What we really have, in many instances, is a delegation of censorship. What I mean by that is that the dichotomy between private and public action is being exploited to permit a power of censorship to corporate power, which is at least theoretically not available to governmental power. In the print media, at least, we have a practice on the part of the press of selling space for editorial advertising. The point is that in broadcasting, we don't even have such a practice. And I'll just give you a little piece from Mr. Justice Brennan's opinion, in case you, because coming from a Supreme Court justice, it may sound more authoritative. He says, the briefs of the broadcasters in this case illustrate the type of journalistic discretion licensees now exercise. And he's got journalistic discretion in quotes. Thus, ABC says in their brief that it would refuse to air those views which it considers scandalous or crackpot. That's quoting from their briefs. While CBS says we will exclude those issues or opinions that are insignificant or trivial. NBC would bar street speech that strays beyond the bounds of normally accepted taste. And WTOP, which is the CBS affiliate in Washington, D.C., says that it would protect the public from subjects that are slight, parochial, or inappropriate. Now, it's this situation which the FCC and the Supreme Court in the CBS case have left unchanged. Well, I've discussed two cases with you tonight. One involves a right of reply to the print media, and the other refuses to recognize, at least as a general proposition, a right of access for the sale of time for political or public discussion on television. What is the difference between the cases? Certainly the principal difference in them is that in the Florida case, a statute created the right of reply. In the CBS case, nothing in the law justified the recognition of a limited right of access to public television time according to the court. So where do these developments leave First Amendment theory today? I would say that we have traveled at least so far as to reach the point where legislation which provides for a structure for debate is not easily to be invalidated on the ground that requiring the media to furnish rights of rebuttal and reply is unconstitutional. I think that the provision by government of a structure for debate and its function as implementing rather than inhibiting First Amendment values is increasingly being understood. On the other hand, there is still a reluctance on the part of the law to find in the First Amendment itself a basis for access to the media. In my own view, Mr. Justice Brennan's dissent makes it very clear that the sheer impact of the broadcast media plus governmental assistance in creating that impact are independent and sufficient reasons for recognizing a right of access to the broadcast media. And it is these realities which I think our attachment to an 18th century conception of the press continues to obscure from view. Critics of the Florida case and of the right of access generally profess to find in the recognition of a right of reply or right of access the end of the First Amendment. Such has been the almost uniform response to the American press thus far to the decision in the Florida case that I told you about. In my view, letting the person whom you attack speak in reply is not the end of First Amendment freedom, but the beginning. Well, that's all I have for you in set remarks, and if you have any questions, I'd be delighted to talk with you about them. Yes, sir. Okay. Yes.
Basically talking about here is trading off free enterprise control of the potential government control. And that's bothers me. I don't think that people that cannot advantage free enterprise control of is governmental.
Well, I don't agree with you. I don't think that we have free enterprise. What we have is our oligopoly. We don't have free enterprise at all. I'm for free enterprise. And in fact, the suggestions that I am making, which would be to yeah.
Will you repeat the question, Jerry?
Yeah. Okay. This gentleman in the front said, I think I state the substance of his question correctly as follows, that he thinks that what I'm talking about involves a trade-off between really free enterprise and governmental regulation, and that he's afraid of more governmental regulation. And is that fair? Well, now you're getting into my answer. I mean, I asked you as whether I had said to your question. You know, if you want to, just let me.
One is worse than the other. Government control is much worse than the other one. At least there's some latitude for citizens to express themselves.
Well, see, that's my point. I don't think there is. You see, I mean, it seems to me when one of the two major political parties in this country is unable to buy time to present its views in any extended way, that I don't think we have freedom of speech, and I don't think people are being allowed to say what they want to say. So, I mean, that's just the fundamental difference between us. I mean, you look at the present situation and say that it is producing freedom of speech, and I'm suggesting to you that I think it fails in some respects. You know, but that's, you know, just a difference of opinion. Yes, sir.
Mr. Monroe the other night said to ask you.
Yeah. Right.
Some-
We've met before. Right.
Yes,
Right.
something along the lines of whether you believe in a free press or a fair press.
Well, I believe in a free press, but I would. I think that's a good question. I believe in a free press and a fair press, I suppose, is the debater's way to answer it. But I'm not going to. Let me say something else about that question. I think it's very important for journalists, journalists to be, as many of you are. We talk about professional responsibility and so on and so forth. It is, I think, very important to realize that the First Amendment does not say that Congress shall make no law respecting the press. It does not say that. What it says is that Congress shall make no law abridging freedom of the press. And that is an entirely different proposition. In other words, I think Mr. Monroe, and certainly he is a fine journalist, and I think he really believes in the message that I read in the paper here today that he gave you the other night. Although I can't see how you could. I can't see how you could look at at the facts, you know, and what he knows to be true of network television, and say that it really is equivalent to freedom of the press. You see, the notion he has of freedom of the press is that freedom of the press is exhausted in the property rights of people who control the media, if you understand what I mean by that. In other words, it's my paper, it's my station, I should be able to do what I please with it. Well, I think that worked in 18th century America, you know, when we had in Philadelphia and Boston and Charleston, we had so many different weekly newspapers, and every colonial printer put out a paper, practically. The power to reach the mass audience, in fact, the reality of the mass audience was just something that was unknown to the 18th century mind. But when you put the power of technology to create this enormous audience, 60 million people watching 3 network TV shows, I think you're in an entirely different ballgame. And then I think it's necessary and I think desirable to ask questions about the boards of directors of those 3 corporations, and to try to provide some structure so that they are somewhat accountable in terms of not of what they say, but at least of opening up part of broadcast time to groups that they might disagree with. At least that's how I look at it. Yes?
I may be monopolizing this a little
That's
bit,
all right.
but another point I wanted to make is what you're asking the press, both electronic and print media, to do is to replace their own judgments almost with some sort of a board, like the government in this case.
Well, I don't think so. I mean, you take this Florida case I told you about. I mean, the obligation of the paper is very clear. I mean, they've attacked someone they know under the Florida statute, which is very specific. If they do that, all they have to do is give them space to reply. A judge is the way it's set up, as a judge would. Well, if it's a state statute, it would be a state judge. If it was a federal statute, it would be a federal judge. We tend to think in this country, although it's a matter of some dispute right now, that the courts are the ultimate arbiters of constitutional questions. And I think it would work here. You know, I really was somewhat annoyed when I read in the Chief Justice's opinion in this case, he gave a whole hymn to editorial discretion. As if anything in here impinges on editorial discretion. Don't forget the issue that in the CBS case was whether we're talking about that block of time which broadcasters reserve for advertising. That's what they're talking about. And they were willing to pay them as much as to sell soap. You see, what they're afraid of is that and they were frank about this, what they're afraid of is that everybody takes baths, see, so an ad about soap isn't offensive. But not everybody's a Republican, not everybody's a Democrat. And so when one side, or a socialist worker or whatever. And so when one side is on a half-hour show, what are people doing? They are doing a terrible thing. They are turning the dial, you see. And that is the real reason, which is a commercial reason, for the reason the networks fought this case all the way to the Supreme Court in the United States. But in response to your question, it would be enforced by a judge. You know, the Miami Herald, after this case was announced, said that this decision was a return to the Dark Ages. Well, it's been a long time since I studied medieval history, but I never recall the Dark Ages as being characterized by free debate and a right of reply. You know, I mean, I just think there's a lot of bunk, you know, that is being pronounced about the meaning of right of reply legislation. I think it's monstrous to say that a paper that dominates the state can ruin someone politically and forever, and that such a person should dare to ask for a reply is considered to be unconstitutional. I mean, and that's the facts. Those are the facts of the case. Yes?
How do you think the difference in the mediums in the two cases you just described?
Well, you notice they are different. They're different. You mean, what are the differences in terms of this? Well, because I don't know what the Supreme Court's going to do, in this case, in the Florida case. I hope they'll affirm the Florida court, and if it goes to the Supreme Court, I suppose I'll argue it there. But I don't know what they'll decide. Maybe they'll say that the Florida court was wrong. We don't know. But I suppose there is some difference between the cases. Legally, the big difference was that you had a law that you could rely on in the Florida case, and you didn't really have one in the CBS case. In terms of the media themselves, I think there was a problem in the way the case was cast in the CBS case. It looked like the groups there were asking for more than I think they really wanted. It looked like they were saying they had an unlimited right to advertising time. They really weren't saying that. What they were saying was that the networks couldn't have a policy of never selling them editorial advertising time. But I don't think it was terribly clear. And if you're asking for an unlimited right of access to the electronic media, I think if you're going to have commercial broadcasting, and as far as I'm concerned, we should continue to have commercial broadcasting as one alternative in the electronic media. You cannot have an unlimited right of access. That is clear. What they were talking about was a limited right of access. What they were saying was you couldn't discriminate against one class of advertising, editorial or idea advertising. And I don't know if that answers your question, but maybe it illuminates it.
There was a kind of breakdown in communication between CBS.
Well, I don't know. There may well have been. It is. I have had the experience, as anybody, I suppose, who's identified with a view has had, of having views attributed to me which are very extreme, which are sort of supposed to be carrying one's argument to the extreme. And that is often a forensic technique. Suppose the idea is, you carry it to its logical or its absurd extreme, and then people will run from it. And how much of that there was in the Supreme Court's decision, and how much there was in the genuine failure of communication, I don't know. I don't know. Yes.
Realizing the space limitation in the print media, just the very nature of the editing process by the volume of copy, what practical suggestions do you have for more complete access over and above the traditional letters page, or the possibility
Well,
of having guests?
I have all. Yeah, I'm sorry, I'm forgetting to do that. Right. The question was, in view of the space limitations in the paper, and there are only space limitations for things that don't pay, which is the same thing as in broadcasting. But in view of the space limitations, what other kinds of access can you think of besides letters to the editor, and what else? And possible guest columnists. Well, I really have just been advocating two species, really, of access to the print media. And that would be a right of reply, such as was the issue in the Florida case. And the other is a right of non-discriminatory access to editorial advertising. So that if a group wants to buy an ad in the only paper in town, as long as they're willing to pay the rate and there's space available, it should be sold to them. It should not be an ideological basis should not be the ground of not selling editorial advertising. And I would limit it to that, you see. Now, some have suggested what the access concept could mean, that you could read the whole paper and see whether a particular view is being covered and then ask that the view be covered. Other people have said, I think Ben Bekdikian wrote an amusing piece in the Columbia Journalism Review and said, would I make, if John Banshaf had a newspaper, would I make him put in cigarette commercials? And I, along the same lines, would you make the Seventh-day Adventist newspaper take ads for Sunday worship? And of course, those are all, I think, absurd. What I'm talking about is the daily press. What I'm talking about is the only newspaper in the community, not a weekly or a house organ or a religious newspaper. I'm talking about the real marketplace of opinion insofar as that we all share together, which in my judgment is primetime television and the daily press. That's what I'm talking about. And I think, as you can see, it is a very uphill fight to get the right of reply accepted, never mind other suggestions. And I'll be very happy if the Supreme Court affirms the Supreme Court of Florida, and if it gets us to a modest right of reply. Because, you see, I don't really take a sinister view at all of the American press. I think that what's going to happen is that these cases won't go into court very much. I think what will happen is that an editor will say, even though someone's criticized an advertiser or something, if he gets any flack, will say, look, this is the law. I have to give space to this other fellow, you see. I mean, I don't really think it's going to be administratively much of a problem. Yes.
Just one more question, please.
Yes.
Is sometimes blamed for a lack of severity on the broadcast.
Yes.
part. Would that affect
Well, I think I should talk about that. I will. That's a very good question, and I think it's a real problem. The question is this: some people have said that the fairness doctrine and the access principle, instead of as they profess to do, making more opinion available, actually tend to be a depressant on opinion. And if I may spell out your argument, I think what you're saying is that if I, as a broadcaster, know that if I put on X, I've got to put on anti-X. And I certainly don't want to do that because that group are crazy and no one will listen to them, and I just don't want them on. So rather than have to be exposed to that kind of opposition,